During the Federalist-Anti-Federalist debate, Anti-Federalists who opposed the Constitution as it was proposed argued that the Constitution lacked a Bill of Rights. Unless rights were spelled out, they could be too easily ignored. A Bill of Rights was necessary as an addition to protect such basic liberties as freedom of speech and religion. Several states had agreed to ratify the Constitution or make official on the condition that a Bill of Rights would be added. There are a total of 27 amendments to the Constitution, and the first 10 are the Bill of Rights. James Madison, who was influenced by George Mason's The Virginia Declaration of Rights, originally proposed the Bill of Rights. It was originally proposed as 12 amendments, but the states approved 10 of these in 1791. The purpose of this action was to limit the power of the government. Further amendments have been added throughout the years, and the current total of 27 may eventually be more. The First Amendment to the Constitution states that Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. In regular terms, this translates to freedom of religion, speech, press, to meet in groups, and to petition. This amendment is extremely important because we use these rights every day, whether we realize it or not. The Second Amendment to the Constitution states that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This amendment translates to the right to bear arms. It also keeps the government from being able to impose tyranny. With this amendment, people have the right to protect themselves, and the government cannot take these rights away because the people can resist. The Third Amendment to the Constitution states that no soldier shall, in time of peace, be quartered in any house without the consent of the owner, not in time of war, but in a manner to be prescribed by the law. What this really means is that the government cannot force you to shelter soldiers in your home without your consent. This is important because it prevents the military from entering the private property of civilians during peacetime. It also limits the use of private property by the military in wartime. The only exception is in cases pertaining to national security. Amendments 4 through 8 are considered the rights of the accused. The Fourth Amendment states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. This translates to the fact that your house can't be searched by the police without a warrant given by a judge. They also need probable cause, which means they need a legitimate reason to search. This amendment is important because it limits the government from doing whatever it wants. The Fifth Amendment to the Constitution addresses the rights of the accused. Within the language of this amendment, certain rights are guaranteed, dealing with double jeopardy, pleading the fifth, due process, and eminent domain. According to this amendment, you cannot be tried for the same crime twice, which is double jeopardy. In addition, you do not have to testify against yourself, which is what it means to plead the fifth. You are also guaranteed due process of law before convicted, which means that your rights given to you must be respected by the state. Finally, under eminent domain, the government can take your property for public use, but must pay you for it. A historical example is the Steuben House, which was taken twice under eminent domain. This amendment encompasses a lot, and it is important because it specifies legal safeguards for those who are accused of crimes. The Sixth Amendment to the Constitution states that, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. What this means is that you are guaranteed the right to a speedy trial by an impartial jury, which means that they do not favor either side. You must also be told of your charges, and you must be provided a lawyer if you cannot afford one. If you have ever seen an episode of Law & Order, this amendment will sound familiar when they read someone being arrested their Miranda rights. You will hear them say things like, if you cannot afford a lawyer, one will be provided for you. The Seventh Amendment to the Constitution states that, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. When the Seventh Amendment was written in the 1700s, $20 was considered a lot of money. Today, any disputes that involve amounts less than $75,000 will not be handled in a federal court. The Eighth Amendment to the Constitution states that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This means that the federal government is prohibited from imposing very harsh punishments that don't match the crime committed. Cruel and unusual punishment is also banned, which causes some controversy over what is considered cruel and unusual. Some people feel the death penalty is cruel and unusual, while others feel it is a just punishment in certain circumstances. Various Supreme Court cases have addressed this issue. For example, Gregg v. Georgia in 1976 upheld the death penalty, while Roper v. Simons in 2005 established that the death penalty was not an option for crimes committed by minors. The Eighth Amendment can also shape how capital punishment is carried out. For example, as of 2013, 18 states and Washington, D.C. have abolished the death penalty. Of those states where it is still legal, lethal injection is a common form of execution. A few states still allow electrocution, and Oklahoma even allows a firing squad. According to the Ninth Amendment, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Although vague, this amendment means that rights not mentioned in the Constitution belong to the people. This amendment has not yet been used to justify the protection of any right not already listed in the Constitution, and it is still unclear about which rights Madison had in mind when he wrote this amendment. Ultimately, the Ninth Amendment assures people that there are rights that members of a free society are entitled to, although they were not explicitly stated. The Tenth Amendment to the Constitution states that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. This means any power that is not given to the national government, but is not denied to the states, then belongs to the states. Examples of laws that the states make involve marriage, divorce, driver's licenses, state taxes, and job and school requirements. This amendment is important because it keeps in mind states' rights and limits the power of the federal government. The 11th Amendment to the Constitution states that the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. This literally means that you can only sue a state in state court. The 12th Amendment to the Constitution is very lengthy in its speech, but it outlines the procedure that electors vote for the president and the vice president together. Amendments 13 through 15 are known as the Civil War Amendments. The 13th Amendment to the Constitution officially freed the slaves. It states that neither slavery nor involuntary servitude shall exist within the United States. This was an extremely important amendment, officially making it unconstitutional to practice slavery. The 14th Amendment to the Constitution states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This amendment grants citizenship to African Americans and also provides equal protection under the law to all citizens. The 15th Amendment to the Constitution states that the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude. This means that African American men now were given the right to vote. A key term related to this amendment is the concept of suffrage. Suffrage refers to the right to vote. So to recap, among the Civil War amendments, African American men experienced the end of slavery, gained citizenship, and gained the right to vote. The 16th Amendment to the Constitution states that the Congress shall have power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. This means that Congress has the power to levy income taxes. The 17th Amendment to the Constitution declared that senators would now be elected by popular vote, which means they would be elected directly by the people. Before this amendment was added to the Constitution, senators were elected by the state legislature. This amendment is important because it strengthened the link between citizens and the federal government. The 18th Amendment to the Constitution states that, after 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. This amendment made alcohol illegal. This amendment, known as Prohibition, did not make it illegal to drink alcohol, just to buy, sell, manufacture, or transport alcoholic beverages. The 19th Amendment to the Constitution states that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. This amendment is extremely important because it gave women the right to vote after a long struggle within the women's suffrage movement. The 20th Amendment to the Constitution states that the President takes office or is inaugurated on January 20th. It also outlines that Congress begins the year's meetings on January 3rd. This amendment is important because it reduces the amount of time lame duck presidents and congressmen are in office before the new administration takes over. A lame duck president, for example, is the president whose successor has already been elected. The president is often seen as having less influence because they have little time left in office. The 21st Amendment to the Constitution repeals the 18th Amendment, ending Prohibition. Prohibition was ultimately repealed because it failed to enforce sobriety among the nation, and it cost billions to enforce. It had lost much support by the 1930s. The 22nd Amendment to the Constitution limits the president to 2 full terms. This precedent had been set by George Washington but was never documented in the Constitution. Franklin Delano Roosevelt was the only president to serve more than 2 terms, and in 1944 he was elected to a 4th term. This amendment is important because it sets limits on administrative power. The 23rd Amendment to the Constitution finally allows residents of Washington, D.C. to vote for the president. Under the Electoral College system, Washington, D.C. is allotted 3 electoral votes for president. The 24th Amendment to the Constitution outlaws poll taxes. Poll taxes were a fee that people had to pay before they could vote during an election. They were originally instituted in part to discourage poor people from voting, especially newly freed blacks in the South after the Civil War. This amendment was important because it officially made the practice unconstitutional. The 25th Amendment to the Constitution outlines the succession of the presidency. If the president dies, resigns, or is removed, then the vice president becomes president. A vacancy in the vice president's position can be filled by the president's nomination and a confirmation by a majority vote of both houses of Congress. The 26th Amendment to the Constitution reduces the voting age to 18. Prior to this amendment, the age to vote was 21. Passed in 1971, this amendment had a lot to do with the fact that young men were fighting for their country at the age of 18 but were not yet allowed to vote. The 27th Amendment to the Constitution, which is the final amendment, outlines that congressional pay raises will be delayed until the start of the new term. The purpose of this amendment was to prevent Congress from giving themselves excessive pay raises while they were still in office.